Rehnquist.
Now he's alive and sitting, and my friend. He's a brilliant guy, fun to be with, and of a bizarre sense of humor. I don't see him as often as I'd like to. And he's a little older than I am, and that's old. So I believe that Bill will go down as a great Chief Justice. You know, the court has a way, it seems, of making liberals come more to the center, and for making conservatives come more to the center. And Bill, by nature, is extraordinarily conservative. At least he was when he went on the bench. But I think, like everybody else, the experience tends to bring it to the middle. And I think he's an outstanding justice. I haven't read all his stuff, and I don't intend to read all his stuff. But it's good.
He comes in a term after, or at least halfway through a term.
Halfway through the second term.
What'd you think of him? He walks in one day, there's a guy named William Rehnquist. Does it mean anything? I mean, I wouldn't say mean anything to you, but here's a young kid out of Stanford Law School, and it's your job to be his tutor.
In a sense, yeah. I had no problem with it. Now, you might wonder why it was he showed up there at that time, because I had been working there by myself. And he and I puzzled over that for some years. And it suddenly dawned on me a couple of years ago when we were talking that I had been called back in the Navy. So right about that time, Justice Jackson didn't know how long I was going to be there. So he brought Bill in, and thank God he did, because Bill and I hit it off just like that. We were the only two conservatives in the whole court, among the clerks.
Yeah.
But he's a fine man and a good friend and fun to be with.
During your term where your clerkships overlapped, I'm sure you had very interesting cases, but one of them was the
The Seizure case.
He spends a lot of time in that book on the Supreme Court concerning that case. Among the clerks, was there a lot of speculation as to what was going on? And maybe I should stop, and for the benefit of those who didn't have the benefit of reading the book, maybe you can give just a quick overview of what the issue was.
Well, boy, I should have reread it if you're going to ask me things like that. The case was Youngstown Sheeton's Tube Company v. Sawyer. I believe the steel companies were threatened to be shut down in a strike. So President Truman couldn't have that. This was the Korean War. So he issued a proclamation seizing the steel mills. And, well, that was not well received. To make a long story short, that case moved faster than any I've ever seen. And in nothing flat, it was at the Supreme Court. His recollection of course, he's there, we can reread stuff. His recollection of it is a lot more clear than mine. Of course, we all knew it was a very significant case, and it was interesting, but as I say, it moved quickly, involved a really important principle, which you really don't going to run into very often, and produced, I think it was 9 opinions. There was, again, if memory serves, there was no majority opinion. But I believe all of them pretty much agreed with the result.
The result was?
Well, they overturned the seizure. Now, a few months after that, Justice Black used to have a dinner for the Supreme Court over at his home in Alexandria after the close of every session. And they were, this particular evening, all the justices were there, and they had dinner, and the president used to come. So, President Truman was there. And they got to talking, evidently, about the Seizure case. And, Truman said to them, he said, I almost came up to argue that case myself. And Justice Douglas leaned over and clapped him on the knee and said, why didn't you do it? Happily he didn't. Yeah. That bears on the steel seizure case. This are the kind of things that we write memoranda relating to what the matter was before the court. And this one, I don't know how many I wrote on this case, but here, I don't know, maybe you're not interested in this.
I would be.
Let me just assure you that we are.
This is a memo I wrote to him about that matter.
George, this is unbelievable. From a history perspective. In fact, Professor Barrett was just part of a panel in Pittsburgh last year where they talked about the anniversary of the steel seizure case. And they had some attorneys who were with the Truman administration there to kind of explain, what the thinking was in the White House and how they felt about the decision and its legacy.
At that time, it was Justice Black's habit to invite the members of the court to his home in Alexandria for a dinner. And next to his home, I believe it was, he had a tennis court because he was an avid tennis player. And one of the qualifications for being one of Black's clerks was to play tennis. In any case, at that dinner that night, he had also invited Harry Truman, who came. And Justice Douglas was sitting next to him, and they were talking about the steel seizure case, and Truman apparently said, among other things, I almost came up and argued that case myself. And Douglas clapped him on the knee and said, well, why didn't you? Oh.
So especially in the steel seizure case.
Right.
And in fact, in your friend, Chief Justice Rehnquist's book, he talks about how once they granted certiorari, Justice Jackson suggested in a somewhat offhand way that both George and I should familiarize ourselves with the briefs in the case when they came in, but he certainly gave no indication at that point to me, at any rate, of any leanings he might have had. What was the buzz? It happened so quickly. Yeah.
Well, my take on all that, because I've been, recently I commented in a note to the Chief Justice how the nature of the cases that come before the court has changed from our time, and we don't have the issues we have now. And then he reminded me, don't forget the steel seizure case. And I hadn't forgotten it. I took away from the court a complete set of the briefs in that case. I have no idea where they are now. At some point in some house cleaning out they went. But my memory of the case is not as distinct as Bill's. I remember, obviously you couldn't help but be impressed by it, and the importance of it, but the thing that stuck in my mind at the time, almost more than anything else, was how quickly it moved. You know, it was in and it was gone. The result surprised nobody. And it didn't surprise me. And an interesting aside in that, after they announced the decision at that time, Tom Clark sat on one side of Jackson, probably on the left. And Tom Clark announced his concurrence, and I don't remember whether he wrote an opinion or not. But Jackson leaned over to him and whispered, "I'm glad to see that you've decided to be a judge, Tom." Now, Jackson told me that, and I'm sure he did.
And that was on decision day. That's it.
Yes, when they announced the decision from the bench.
Right. That's not what Harry Truman thought Tom Clark had become.
No. But at that point, it became clear that Tom Clark had become a judge.
Chief Justice Rehnquist rewrites in his book that after the conference, George Niebank and I were both present and eager to learn the outcome when the justices went into conference. Describes the custom. And then the conference ends at about 4 o'clock in the afternoon, and George and I hung around the door waiting for Justice Jackson to make his appearance. He told us to come into his chambers as he usually did after conference, and we had no sooner sat down with our tongues all but hanging out when he looked at us and said, "Do you remember that?"
Yeah. The president got B or something like that.
Well, boys, the president got licked. That wasn't a surprise to you as far as the results?
No. Of course, by that time the thing was all settled, but it didn't surprise me. I don't think it surprised anybody.
Did Jackson elaborate at all? I mean, aside from...
No.
You guys were really...
But you know, the thing is, it's the kind of issue that you can research until you're blue in the face, and you're not going to find a whole lot. And so it wasn't one of those where you get a really exhaustive supply of research materials and things upon which to rely in writing an opinion.
Rehnquist states that it is one of those celebrated constitutional cases where what might be called the tide of public opinion suddenly began to run against the government for a number of reasons, and that this tide of public opinion had a considerable influence on the court. Do you agree?
I certainly was not aware of it.
Yeah.
You know, it isn't that the Supreme Court doesn't follow the election returns,
Right.
but I just can't answer that. If there was, in the 50 years after the fact, I don't remember it.
In that context, or more generally, would Justice Jackson give voice to any of his opinions about Harry Truman?
Well, no. He was not one to generally to speak of other people. He did on occasion, but I was telling, guess you weren't here when I told the story about at a dinner at Justice Black's. Did you hear me tell that story?
No, I think I've heard you tell it on videotape.
Oh, okay.
Go ahead.
Go ahead.
Where the justices and President Truman were at this dinner at Justice Black's house, which was a routine for him following a court session. And apparently they got to discussing the steel seizure case, and Truman said, "Well, you know, I almost came up and argued that case myself." And Douglas leaned over and clapped him on the knee and said, "Why didn't you?"
He probably would have done a better job than Perlman did.
Perlman was a... well, I think he probably would have. Perlman, I'll never forget him. I thank you for bringing that name up, because I was going to look it up, because I remember that man very, very well. He used to make a theatrical production out of motions for admissions to the court. And that sort of, in my mind, leads to this. And I think others pretty much shared the same experience. When you first go to the court, you know, it's an enthralling, and you go and you have those special spots you can sit and listen to oral argument. And after a couple of months of listening to oral arguments, I decided that I had better things to do, mostly than do that, because the arguments were tedious, boring, and the most important things in the cases were the briefs. And it concluded, and that's not original with me, that you don't win cases on oral argument, but you sure as heck can lose them. Some of the outstanding people I heard argue was, for example, John W. Davis.
You didn't steal Seizure.
Yeah,
Yeah.
he was good.
Right.
And it was when I was thinking of him, when I had occasion to argue some things myself, to remember how it was that he argued. And it wasn't bombastic. He just sort of draped himself around the lectern and talked. And he was good, very good.
Right.
There are mostly lawyers that really don't know what they're doing there, who make these bombastic jury-like arguments, which of course don't cut the ice at all. It doesn't help. As for the most part, those cases are decided before the oral argument anyway. I didn't say that. Well, they make up their mind principally on the basis of the briefs, and what the briefs serve sometime is to provide fodder for questions for the argument. And so except when people like John W. Davis came to argue, I didn't bother with oral arguments much thereafter.
During your 2 years, do you remember Thurgood Marshall arguing? I'm not sure there was a big...
He was not there.
Yeah, I don't know. Just before you were there and just after you were gone, he had big cases.
He may have argued it. No, I don't think he did while I was there.
Okay.
So I can't comment on his style or effectiveness.
Would Jackson critique the advocates? Did you ever get a little post-game evaluation? Because he'd been SG and himself such a great advocate.
No.
No, okay.
No, he didn't. It just wasn't his style generally
Right.
to comment on other people's work.
Okay.
Unfortunately, the great number of cases that come before the court are not as well represented as they could be. I'm really getting on thin ice now, and I know that. But so often the lawyers really don't know what's going on at the court and tend to argue the merits instead of other points. Now,